talk a little bit about debt resolution as opposed to bankruptcy. Maybe 3 or 4 alternatives to a bankruptcy filing. The first is, instead of filing for bankruptcy, you could put money in a bank account and attempt to save up that money over time. And I think when you take your credit counseling class, you will be told that generally most creditors will settle for about 67 cents on the dollar, 2/3 of the principal amount sought, if you pay them in cash. And I have reason to believe that's generally true. So one alternative to bankruptcy would be for you to save money in a bank account, and then ultimately when the creditor comes to sue you, or ultimately when you save the money and you're able to negotiate with them, you could offer them 2/3 of the amount due. Another alternative to bankruptcy, and I have referred clients to them, is if you have only credit card debt, you could go to a credit counselor such as Money Management International. And I've sent a number of clients to Money Management International over the years. And what Money Management International could do is perhaps reduce the interest rates on your cards to 2 to 3, 4%, and allow you to pay those cards back over a 5-year period with a reduced interest rate. And credit counseling is very similar to Chapter 13 bankruptcy, because you can make payments to the credit counseling entity, and they will then pay your creditors. And that is a reasonable alternative to a Chapter 13 filing. And occasionally I do refer clients to Money Management International. Similarly, they actually refer clients to me, because they have clients where they've tried to put together a plan and could not do so. Money Management International or credit counseling will not reduce the principal of the credit cards. They will only reduce the interest rate to 2 to 3%. Only a Chapter 13 bankruptcy can actually reduce the principal payments back to the creditor. And what I mean by principal payments is, say you owed the creditor $1,000. A Chapter 13 bankruptcy can reduce the payment back to the creditor to, say, $300 or 30 cents on the dollar. So that's an advantage of a Chapter 13. Another alternative to bankruptcy would be a debt consolidation loan. I frequently see clients go to credit unions or lending club or Prosper for debt consolidation loans. They're usually not successful. I hate to kind of give you the bad news, but many times the interest rate on the consolidation loan is very high, and because it's a high interest rate, it does not bode well for the client to successfully make those payments, because the interest rate is just simply too high. And if you think about it, if you're overburdened with debt and you have a debt consolidation loan, it is fair for the creditor to charge you a higher interest rate because the risk of default is higher. But unfortunately, because the risk of default is higher, I have a number of clients who have debt consolidation loans who have now filed for bankruptcy. And also the credit union will probably take additional collateral, like you may have had a vehicle paid off, and with the debt consolidation loan, you then gave up equity in the vehicle in support to secure the loan. The final alternative to a bankruptcy is debt resolution. And you will see, or you've heard you'll see online ads. If you type in the word bankruptcy on the internet, instantly you'll get several references to debt resolution companies. In particular, there's National Debt Resolution and Freedom Debt Resolution. These companies are all generally based in Silicon Valley. And actually, debt resolution has an old history. It used to be called debt proration. It was started in the Great Depression. The problem with debt resolution as a form of relief is, it does not have an automatic stay. And I spoke, or you may hear another video from me about the automatic stay. There is no automatic stay in a debt resolution. And so generally what happens is one of your credit cards will not participate in the program, and eventually that credit card company will sue you and garnish you, and then once you're subjected to a garnishment, you default on your debt resolution plan. That's typical of what I see. The other issues with debt resolution plans is there is what's called discharge of indebtedness income, meaning if the debt resolution company gets a benefit for you and they settle on the debt, instead of paying 100 cents on the dollar, you pay 50 cents on the dollar. Well, under the Internal Revenue Code, you're actually liable for that 50% that was forgiven, and it's ordinary income. So I've had clients who come to me after debt resolution with 1099 discharge of indebtedness income, and they say, I had no idea that I would actually pay income tax on the unforgiven debt, and you would. Congress allows bankruptcies, however, are non-taxable events. So in a bankruptcy, the debt's forgiven, you don't have to pay income tax on it. So because debt resolution companies lack the automatic stay, because you pay income tax on them, I don't recommend them. And the other reason I don't recommend the debt resolution is I've seen numerous times clients will have a significant amount of IRS debt, or or debt owed on their house or car. And you know, these debt resolution companies say they're not your attorney. They're not out to look for you for a holistic approach. They're not looking at things from 10,000 feet and deciding what the best course of action is for you. All they're looking at is the unsecured creditors only. And that sort of myopic or narrow scope means that they're not looking at the whole picture. They don't owe you a fiduciary duty, and frankly, I don't recommend them. And at the moment in the Commonwealth of Virginia, they're not allowed. Last year in 2018, there was a bill before the General Assembly to allow debt resolution in the Commonwealth of Virginia. It did not pass. I certainly intend to testify when this issue comes up in the next General Assembly or thereafter, because if you go onto the website of the Federal Trade Commission, or you look in literature concerning debt resolutions, it is well recognized by attorneys generals around the United States and by consumer advocates that it is really not a good solution for you as a debtor.